Ladies and gentlemen, a big round of applause from the Pacific Legal Foundation, the great Kathy Hoekstra. Woo!
Thank you. Queen of Saginaw. That's a new one on me. I am a Development Communications Officer with the Pacific Legal Foundation. We are a public interest law firm that has been around since 1973, kind of akin to Institute for Justice, IJ. We just celebrated our 45th anniversary. We had a gala celebration at the Ronald Reagan Library and Museum in Simi Valley. And I'll tell you what, if any place, if you've never been there, go. I've never been there before, and it was just amazing. I needed more time to go through the whole museum, but our banquet area, a huge room with Air Force One suspended above us. It was very cool. And the Pacific Legal Foundation has an unmatched record of success of all other organizations of its kind. That includes IJ, and sheer numbers, for one thing. In 2017, PLF had more than 150 active cases in courtrooms around the country. We're talking state level as well as federal level. Last week, and I will get to this because I think just seeing the flags here, you guys are definitely going to want to hear about this case. Just last week, PLF litigated its 12th case at the Supreme Court of the United States. The 12th case. And we've got two more coming up this year. We just learned of what will be the 14th case on Monday. And then in the middle, we had another grant for Supreme Court announced they will take up another case. So a very busy year. Again, unmatched record of success. And our cases focus on three areas of constitutional focus: property rights, personal liberties, and procedural guarantees. And, I can talk about a lot of those. But I want to get to some of our some of the successes at the Supreme Court, which has reverberated for freedom around the country. And I wrote these down because I want to make sure I get these right. In 1987, for instance, and again, I'm just touching on a couple of these. 1987, in a case known as Nollan, Nollan, the Supreme Court, it was a property rights case, ruled in favor of liberty, holding that government must pay for property rights taken from landowners. It established what some of you might know, if you're familiar with legal stuff, established the essential nexus test, limiting the ability of government to demand property in exchange for permits. Real significant thing about the Nollan case, Nollan is taught in every law school curriculum on land use in the country. So that's a big one. Which leads us up to something from right here in Michigan. In 2006, you may recall the Rapanos v. U.S. Remember the gentleman from up in the sort of the rural area in the northern central part of the state, the gentleman who wanted to build a parking lot or expand his parking lot. And the government came in and said, no, that's a wetland. You can't do that. So that case went to the Supreme Court. And in that case, it was a victory for us. However, it was a 4-4-1 decision. And this is what, this one narrowed the Clean Water Act. So government can't micromanage property near what we call navigable waters. Now, again, anybody who follows property rights cases, in particular the Wetlands and the Clean Water Act, understand that there has been a lot of confusion over the last 12 years about just what navigable waters are. And that led to the creation of the Waters of the United States rule in 2015 under the previous presidential administration, which basically tried to exercise federal control over every puddle, every ditch that could possibly collect water. Just another avenue for egregious government overreach. Well, let's flash forward to last year when we had another case challenging the Waters of the U.S. rule, and our case was wrapped into into a whole bunch of other ones. Now, this challenged the rule. It might get a little technical, not quite on the rule itself, but it was a matter of not only did the EPA put this rule into, promulgate this rule, right, the waters of the United States, they also tried to rewrite the way you and I could challenge this rule in court. They basically said, no, you can only go to federal appeals courts. You can only do it this way. Oh, and by the way, you only have 120 days to challenge this rule if somebody comes on your property and says it's wetland. Well, a whole bunch of people challenged it and said, you know what? This is a violation of our U.S. constitutional rights, our property rights. We should be able to go to any federal court in the country and challenge this thing. Well, in January, the case was heard back in the fall, and in January, the justices issued a unanimous decision in favor of property owners all over the country. Written by Justice Sotomayor, by the way. And what that does, what that unanimous decision did, is it increases access to justice for Americans who are aggrieved and victimized by this overreach of the Clean Water Act. So yay. So let's get to the case that was heard last week. And I will ask you, Michigan Steve, that top little flyer you have right there, the one up the guys, yeah. Just take a look at that and pass it around. I do apologize. I was not able to get my hands on enough of some of our, the one in your right hand. Yep, take a look at that, send it around, because that's the case I'm going to talk about right now. Minnesota Voters Alliance versus V. Mansky. This is a case out of Minnesota. And what Steve is going to pass around is one of our monthly publications. It's called At Stake, and you will have a chance to sign up to receive these for free. But you just take a look at it first and see what you think. Andy Silek is a gentleman who went to vote in the 2010 election. Right? He was a member of the Tea Party. And unbeknownst to the election judges or anybody at the voting booth, he was also the executive director of an organization called Minnesota Voters Alliance, which advocates for voting integrity at the voting booth, et cetera, voter ID laws, promoting that sort of thing. So Andy walks into the voting booth wearing a T-shirt that says, "Don't tread on me." Don't tread on me. There's also a smaller logo of the Gadsden flag. And he also had a pin that said, "Please ID me." So he goes into the booth, and the election judge says, "Oh no, that's political. Under state law, you either have to remove your apparel or turn it inside out so nobody can see it." And Andy said, yeah, exactly. He said, "I don't think so." He left, came back, was given a hard time the second time around. Finally, after 5 hours of going back and forth with the election judges, they finally let him in to vote. But under state law, these election judges are also allowed to take down his name for possible persecution, for fines, right? So Andy said, "I don't think they know who they're messing with. I'm the executive director of the Minnesota Voters Alliance. I know my rights. This is a violation of my free speech rights under the First Amendment, because I have a right. Even the voting booth is not a First Amendment free zone," right? So Andy fought that, and he got a couple of other folks with him, and fought it, took it to various federal courts, and eventually Pacific Legal Foundation got involved, and it went to the Supreme Court of the United States, and it was heard last Wednesday. And the argument being, you and I have a right to express our views and express our values passively at the voting booth as we do anywhere else. And I'll tell you what, if anybody, and this, by the way, this is our website, pacificlegal.org. Really easy, all one word. You can go there, and I'm going to tell you about the case that's on our front page is what you see right there in just a minute. But yeah, so, and what you're seeing is the at stake. It's a little sort of a summary of Andy's case about Minnesota Voters Alliance v. Maskey. Now, this was written before last week. This came out last month, so keep that in mind. So yeah, we'll wait to see, but, reading the transcript, and I listened to the audio of the Supreme Court arguments, and we're kind of all taking little bets. We're thinking at least 7-2 in favor of liberty in this one. Just listening to the judges. Justice Gorsuch and especially Justice Alito really put it to the opposing counsel, the gentleman defending the state of Minnesota's law. There are about 9 other states, I think, and the District of Columbia who have such strict voting apparel laws as well. So we expect a decision in that in June. Now, we just learned Monday that this case is going to, if you can even scroll down a little bit if you want there, right there, grave concern. This is a case out of Pennsylvania, and it gets a tiny bit technical, but what springboards you to this technical stuff is just outrageous. There's a woman named Rosemary Nick, and you can read about the case. She lives on a quiet 90-acre farm that's in rural Pennsylvania. It's been in her family for 50 years or so. Well, about several years ago, somebody went to her township and said, you know what? We think there might be a burial site, an old graveyard or an ancient burial on this lady's farm. So the township said, oh, well, we better check this out. So the township hurried up and passed an ordinance that said, we can go on Rosemary's property and verify this, and if we find that there's a grave site, she has to let the public access her property to visit it. So sure enough, the township trespasses on her property, invades her property, no warrant, no consent, because this ordinance says it's okay. They find what they think might be a burial site, right? So now she has to let people access her property so they can go visit this burial site. Well, Rosemary said, no. A, you're violating my Fourth Amendment protections, guaranteeing due process, and warrantless searches, protections against warrantless searches, and also, by the way, you're violating my Fifth Amendment protections from government taking my property without compensation, without the just compensation. So Rosemary took this matter to a federal district court. State, she knew she wasn't going to get anywhere in the state. I think she had tried a couple different avenues. So she goes to the federal district court, and they said, you know what, we're not even going to hear your case because you have not exhausted all of your legal options on the state level. Now this is where the Supreme Court is coming in on this. The federal court, or the federal district court, says that they can do this. This is a procedural gimmick that the federal courts use under a 33-year-old precedent called Williamson County, where you are supposed to exhaust all of your legal options at the state level before you can go to the federal level. Well, this has not been properly challenged until now. PLF has come in, and the justices, in their wisdom, have realized that this particular precedent has not been challenged properly when it comes to property rights takings under the Fifth Amendment. So they agreed to hear this case not on the validity or the merits of the actual township ordinance that made this stuff all happen in the first place, but they want to take a real hard look at that Williamson County clause, because governments everywhere, or the federal government has long used it to avoid or to basically shut courthouse doors, federal courthouse doors to American citizens whose rights are being violated. So that's what makes this case huge. And that second little flyer right there, yep, that one right there. You can hand that one around too. That second one that Steve's going to just hand around is not this case. It's another one of these at stakes, but it also involves this Williamson County one. This is a case that he's got right there out of North New Orleans. City of New Orleans took a wrecking ball to a couple's rental property without telling them. They bought it. They were going to rehab it and either rent it out or resell it. And the city of New Orleans owned it because it had been foreclosed on years and years prior to a previous owner. Well, the city, apparently their bureaucracies didn't know what the other one was doing, and they took a wrecking ball, destroyed their townhouse that was on this property without telling them. And when this couple went to argue and protest, they said, oh, yeah, sorry. Oh, by the way, here's a bill for $11,000 for demolition. So you'll read about that on that flyer. That one we are currently fighting. Exactly. So you can read about that one. But I want to get to the cases that we do have in Michigan. One of them that we have, it's sort of languishing right now in, you know, how the justice system takes a really long time, is from the Upper Peninsula. We don't often defend government entities, but in this case we are. Marquette County Road Commission. Because up in the UP, you know, there's a mine, you know, takes important things out of the ground so we can go use them. And to get the stuff from the ground to the place where they process it and do stuff with it, trucks for years have been having to take the stuff out of the ground, put it in their trucks, drive it this circuitous route going through Marquette, the city, around Northern Michigan University, and all the way over to where the processing plant is. The Road Commission, Marquette County, the company, everybody has had these plans. They just want to build a road that just goes straight through, relatively speaking, to avoid all of that. It's you know, tons of money and fuel and wear and tear, and plus all the on the roads and the trucks. And then you're going through the city. I mean, these trucks go by how many times a day in the city? But no, the EPA says you guys can't do that. We're not going to give you this permit because wetland. So that's a case we are fighting on behalf of Marquette County and the Marquette County Road Commission. So stay tuned on that one. If you go to our website, there is a search field up at the top. Just type in Marquette and you'll get it. And there's a great video and just showing the ridiculousness of it. And speaking of ridiculous, the one that Dennis mentioned is right here in Oakland County. The search function's way up at the top, but that's okay. People can figure, right up there. Oakland County. Now, I don't know how many people know this, but if you fall behind on your property taxes for a certain period of time, actually any state in the country, eventually your local government will come in and seize your property and remove you, sell the property, foreclose on the property and sell it at auction, right? So in Michigan and I think about 9 other states, Michigan has something that is called the Michigan General Property Tax Act. And if that happens to you or me, in any normal circumstance, the county sells your property. Hey, say I owe $1,000. They'll take the $1,000 and they'll just give me the rest of what they sold the property for. Not in Michigan. Michigan General Property Tax Act allows your county treasurer to foreclose on your property after 3 years of allegedly notifying you if you have a tax debt on your property, and they can foreclose on the property, sell it at auction, and keep the proceeds. Some of you may already know this. I mean, there's been a little bit in the paper. There's a gentleman by the name of Uri Raffaelli who owed, get this, $8.41 on his property. He bought some property back in 2011 here in Oakland County, intending to use it as rental property. And Uri thought he took care of all the taxes, all the penalties, all the fees that had built up prior to his owning it, pays it. That's fine. 2012, 13, 14, he pays everything in full. Come to find out, he mistakenly underpaid those 2011 taxes unknowingly. County says it tried to notify him. He didn't receive the notices. County takes the property under your treasurer, Andy Meisner, takes the property, sells it for $24,000, and just pockets the entire thing for $8. I just learned this weekend because Uri's son-in-law came to our event. We had several of our clients there, and he said technically it was more like $10.59 once you added in, the fees and stuff. And so they've been Uri and another gentleman who went through the same situation had tried to take this to court, tried to fight it, and we're getting nowhere. Enter Pacific Legal Foundation. So we have come in, we have taken Uri, and Andre is a co-plaintiff, and we have petitioned the Supreme Court to review this law and to invalidate just this horrible law. Because how many thousands of Michigan residents have been affected by this for the simple fact that maybe their P.O. box changed, or our other client, Andre Onessian, happened to move to California and hadn't been getting his notices that he was $6,000 behind. Well, Andy Meisner and the county sold his property for $80,000 and pocketed the rest. How many other people is this happening to? So we are again, it's in front of the Supreme Court. We don't know how long it'll take for the Supreme Court to decide whether they're going to review this or not. But our hope is that we can let the Michigan Supreme Court know that there are victims and that state law allows it. And there can be also a legislative fix to this as well. It's not, Supreme Court can invalidate the law, but the legislature can act as well. So those are a couple things to think about. And if you want to pass that magazine around right there, what you guys are looking at, the one pager is called At Stake. And again, it's a write-up on usually just one case. You get to meet the victim. You get to hear their outrageous stories at the hands of government bureaucrats and abuse. And then what Steve has there, it's actually a magazine that comes out 4 times a year called Sword and Scales. This particular one has Andy, Minnesota Voters Alliance, on the cover. And this one features our Supreme Court cases and successes. So you can read all about that. And a nifty little article at the very end, written by somebody, featuring... Well, I actually talked to a donor who got invited and got to witness one of our Supreme Court cases, and it tickled him. He was just so thrilled to know that this is what his donation dollars go to. And finally, Steve, if you will take one and pass it around, we have these little postcards where you can sign up to receive emails that we send out. We send a weekly email called Morning Docket, which just outlines some of the coverage and new things that are going on at PLF in the previous week. You also would get the one-page At Stake and the quarterly Sword and Scales. And that's for free. You can sign up, take a look at it, and just keep tabs on everything. I will tell you the April At Stake, the one-pager, does feature Uri Raffaelli from Oakland County, who I just talked about. So if you sign up, you'll get that one, and you can read a little more about his case. And hopefully, the idea is we're the best public interest legal firm in the country, pro-liberty and pro-freedom, that probably a lot of people haven't heard of. So now you have, and that was what I wanted to make sure you guys all know who we are and where you can find us.